Hello, this is attorney Brian Pendergraft with the Pendergraft firm, and I'm a real estate and landlord-tenant attorney that is licensed to practice law in both Maryland and the District of Columbia. And the topic for today's video is how to evict dangerous tenants and occupants as fast as possible in Maryland. So it's really a lecture on motions for expedited hearings and situations in which I think that they are viable, and also situations where I think that they aren't viable. So, all right, here we go. All right, so first I have to give a quick disclaimer. This is legal information. This is not legal advice. So for legal advice, contact an attorney that is licensed to practice law in, I guess, in Maryland. In Maryland. So, maybe you can contact me, I guess. Alrighty, so here is the order of the presentation. So first I'm going to be discussing what is dangerous. So motions for expedited hearing should only be used in quote unquote dangerous situations. And I actually have a definition for it. And in the second thought, so what isn't dangerous? I'm going to be discussing, what I think doesn't qualify for expedited hearings. And the third thought is how to actually get hearing dates faster. So that is when I will explain the motion for expedited hearing. And number 4, I'm going to be explaining actual motions that I did in situations that an expedited hearing was granted. Thought number 5 is so you will get in the court faster. I mean, not fast enough in my opinion, but you definitely still get into there faster. Point number 6 is that the cause of action does not change. So if you file for failure to pay rent, you have to file for failure to pay rent. You have to file for tenant holding over. You still have to file for tenant holding over. You still have to send the notice to terminate tenancy, wait until after it expires, and then you can file for tenant holding over. You cannot file a day sooner, even in an emergency situation. Same applies for a breach of lease, etc. And number 7, I explain interim solutions, such as again, I don't think that the courts get there, that things get done fast enough, even with expedited hearings. So in the meantime, you may very well need a peace or protective order. That's an interim solution. Another interest in thought number 8, more interim solutions, such as contacting the police or maybe the fire department. And then the last part, I go into my outro. So if you decided to stick around, maybe you like what I have to say. So if you're watching this on YouTube, go ahead and hit that like and subscribe button for your boy. It helps me keep making videos like this when I really should be lawyering right now, but I got to give the people the content that they need. All right, moving on. All right, so my first point, what is dangerous? So to me, or at least this is, I essentially borrow the dangerous definition that is used in a breach of lease case, or what is a substantial breach of lease. And a breach of lease that is substantial is a situation that is dangerous enough where the activity represents a substantial threat to people and or the value of the property. So that is what I've defined as a dangerous situation. Again, I borrowed it from breach of lease cases, but I've been using that same definition in holdover actions or in wrongful detainer cases as well. So if I think that so for example, I actually have some examples here. So for danger to people, say if there is a domestic violence case that represents that one person may be dangerous to the other. So that is a good reason to try to get an expedited hearing. Another example that I use in danger to property, you'll see here is I have a fire hazard on the screen, or maybe some serious health violations. Those are dangerous. Those are dangerous to the property. So those are dangerous situations that I think a motion for an expedited hearing date can help you. Anything else just moves on to my next thought. What is not dangerous? And I pretty much think everything else falls into the not dangerous category. So sometimes people will call me and be like, I need an expedited hearing date because I can't pay my mortgage. Well, too bad. Everyone can't pay their mortgage because their tenant isn't paying, or I'm going into bankruptcy. Well, the court really doesn't care too much about you and your personal issues. Or if you want to say, hey, I want to move in so I can live there. You know what? Maybe I should take that out. I'll keep that I'll keep that here. But maybe I'll use that. Actually, maybe I'll use that one in an argument for a motion for an expedited hearing one day. But as of now, I still don't think that it really qualifies as something that's dangerous. But Or another example is, I am suffering financial harm. Therefore, I need an expedited hearing date. But so is all the other hundreds of people that are filing these cases. You got to keep in mind that these courts are not just reviewing your case, they're reviewing everyone else's. So you have to give the court a really compelling reason to grant a motion for an expedited hearing date to allow for you to skip the line, which is why I think dangerous situations such as it's a serious threat to persons or to property, maybe domestic violence or something like that going on. In that case, it's definitely a good reason to get an expedited hearing date. All right, so moving on. So how to get hearing dates faster. So that is filing the motion for expedited hearing date. So the motion for expedited hearing date needs to be filed at the same time that the case is filed, or at least I think that's the best time to do it, right? The motion will need to actually explain the dangerous circumstances, and it has to request the expedited hearing date as well. So that needs to be done on the motion. So there are no court forms for this. So for me, I just typed it up. The court does have blank motion forms, so you can, I guess, visit your courthouse and get the blank motion forms, and you can fill those out if you need to do it yourself. Or again, you could always hire an attorney to do it as well. And you have to keep in mind that it is within the court's discretion to grant your motion. So you may think something is dangerous that isn't, in which case the court may disagree with you. It may very well even be dangerous, and the court may still disagree with you. So that would really suck. So maybe you can consider hiring an attorney to help you with that. Let's see. All right. So here are actual situations that I use motions for expedited hearing dates to actually get granted, so I can get faster hearing dates. So one example was a holdover case, and the reason was I used the danger to person rule that I just gave you. So a tenant in one unit actually cut off access to electricity to the tenant in the other unit. So I filed a motion explaining that essentially this is a substantial threat to the health and safety of the other occupant, because it may be property uninhabitable for the other one if you're just going to cut off electricity to them. So for that reason, I filed the motion for expedited hearing, say, hey, we got to get this person out because they're going to they're dangerous to the other person, essentially. Another example of a motion for an expedited hearing date that I got granted was actually in a wrongful detainer action. So they were unknown. In this case, they were unknown occupants that didn't allow the new purchaser inside of the property, and the property appeared to be deteriorating from the outside. So I filed a motion explaining that, these people are unknown. They have no relationship with the landlord, with the with the owner. The outside is deteriorating. We don't know what's going on to the inside. And based on what we've observed of the outside, it looks to me like whatever's going on may be a substantial threat to the property. And they actually attach photos of the outside poor conditions of the property to try to make my motion appear more persuasive. And the court found it persuasive. So, they granted it. So good for me. All right. So even if so here's, I guess, the sad part is that if your motion is granted, you will get into court faster, but it isn't fast enough in my opinion. So it may still take up to 4 months to get into court, depending on the cause of action, especially due to the pandemic. So the most recent motion for an expedited hearing date I filed was in, I want to say, early June, and I didn't get a hearing date until at the end of August. Now, if you've been filing cases during this pandemic, though, you would know that, wait a minute, that's actually extremely fast. That's like almost normal time to get a hearing date. But also you got to keep another note that I have here is that some jurisdictions are a lot faster than others. So Prince George's County, where I primarily practice, tends to be pretty slow. Whereas if you're in maybe Carroll County, or maybe things are faster out there, less busy counties than gorgeous Prince George's. That said, it's slow, but it's still a lot faster than these pandemic waiting periods. Because I've had some cases that are taking, non-emergency cases, that are taking over 6 months to get a hearing date. So, and because the courts aren't moving fast enough, which again, may not necessarily be their fault. I mean, it's a pandemic slowing the world down. There are I will discuss interim solutions such as peace orders or protective orders, maybe even contacting the police depending on the situation in a later thought. So, just because there is an emergency situation, the cause of action does not change. So the cause of action remains the same as if it wasn't a dangerous situation. So in a tenant holding over action, that means you're still filing for tenant holding over, and you must still file after the proper notice expires. So in most jurisdictions in Maryland, I think they tend to require a 30-day notice. In some, in other cases, I think Baltimore City may require, let's say, a 60-day notice to terminate a month-to-month tenancy. You may even have to give longer than 60 days notice if your lease requires that, right? Because your lease will trump the law in that case. Let's see, we have to file for failure to pay rent. That means you're still filing for failure to pay rent. And filing for, and if tenant breaches the lease and the cause of action is breach of lease, that means you have to file for breach of lease. That said, breach of lease situations generally require you to send a 30-day notice, but the statute does state that the breach of lease law statute does state that that time period can be shortened to a 14-day notice in a situation that represents a substantial harm to the health of the person or the property. And again, as you'll notice, that is where I borrowed my definition of dangerous from that I've been using in my motions. So off to interim solutions such as peace and protective orders. I want to discuss this because, again, I don't think that the courts are, really moving as fast as I would like them to. So sometimes you may have to, maybe someone is hurting someone else, they may have to file a peace or protective order. So for the first part, I want to define the difference between a peace and a protective order, because they have essentially, they're very similar, but they're just used in different situations. So a protective order is used in a situation where the parties have a close relationship, such as siblings or parents, or maybe they've had a sexual relationship, right? So that is close enough where a protective order is the solution. And a peace order is in the case where there is no close relationship. So if you're watching this and we don't know each other, then, a peace order will be the solution. If you're watching this and you happen to know me and be my sibling, then I guess we could file protective orders against each other. All right. Hopefully a day doesn't come where we have to do that. I know you're watching this, Byron. Let's see. So, here's an observation that I had when it comes to peace and protective orders, particularly in landlord-tenant situations. I've noticed that courts seem to appear to be reluctant to grant peace and protective orders in landlord-tenant situations, because a lot of times they'll understand that there can be situations, for example, in fact, let me talk about one situation where I actually represented a landlord in in a peace order case against a tenant. And the tenant just kind of didn't want the landlord coming around, but the landlord had to come around because it was their property. So again, the courts will, it's almost like a red flag if a landlord-tenant situation comes across their desk. But I'm not saying that they don't grant them, but again, it's like a red flag to them when parties may be living together or a landlord-tenant situation. And in fact, in that situation where I explained earlier, where the tenant cut off access to electricity to the other tenant, I think one tenant filed for try to get a peace and protective order against the other tenant, and the court didn't grant it. And I guess they looked at the situation and saw that they lived together, and then the court was just like, well, once they heard that the people lived together, they thought, well, this is a landlord-tenant issue. In which case, I'm just like, no, it isn't. That was not a landlord-tenant issue. You know what I mean? That is one tenant that is trying to what's it called? Ouster the other tenant, right? That's not a landlord-tenant issue. You guys need to step in. But nevertheless, the court, again, I think once they hear that people are living together, a lot of times they just may want to just throw cases out. So that is why I would, not to self-promote. I'm not doing that, but you're going to accuse me of self-promoting anyway. In fact, you're probably going to accuse this whole video as me doing self-promotion. But I would say in peace and protective orders, particularly in like landlord-tenant situations or situations where people live together, I would highly recommend attorney representation. And another point that I have about peace and protective orders is, you can't see this little bottom part because my head. Okay, there we go. my little screen head was in the way, is that I actually question how practical peace and protective orders are for people that live in the same space. So that's something to keep in mind. Alrighty, right? Because you can't necessarily order someone to stay away from you if they are stay 100 feet away from you if they live in the room next door to you. All right, moving on. Interim solutions, part 2, calling the authorities. So, if you're a victim of domestic violence, please contact the police. Or in the case of a fire, or if there appears to be a fire hazard on the property, please contact the fire department. So that is how we handle that. Don't call me, your lawyer, because I can't help with that. And that is it. So if you have any questions that you would like to be considered for my Ask Attorney P series, you can visit my website at www.tpf.legal/ask. So that link is where you will be able to submit questions for me. And that's it. Thanks for watching. So again, my name is Brian Pendergraft with the Pendergraft firm. Website is www.tpf.legal. And you can shoot me an email at info@tpf.legal if you would like to discuss anything with me. Alrighty. Thanks for watching.